The first part, as I mentioned earlier, is meant to provide you with the basics of copyright law, so copyright fundamentals. To understand how the management of copyright and usage rights works for works created with generative AI systems, we need to understand how copyright law works in general, in a broader sense. And since, generally speaking, this educational content that I have meticulously prepared won't typically be followed or effectively utilized by individuals who already possess a truly solid and comprehensive legal background, I will therefore proceed to show you some fundamental and essential references concerning copyright law. The main reference source is the Berne Convention, which is the primary international convention on copyright. So, the principles I'm showing you in this part of the slides apply more or less to all countries in the world, let's say the main portion of countries that have joined the international conventions on intellectual property. In Article 2, the Berne Convention talks about protected works, that is, what does copyright protect? In other words, copyright is a legal tool used to protect which types of creations. Here, Article 2 starts with a list, but before the list there's a sort of definition. It tells us that the expression literary, thank you. And then it truly begins with a comprehensive and extensive list, okay? This list encompasses various forms of written communication, such as numerous books, detailed pamphlets, and many other diverse forms of writing. Furthermore, it includes various spoken presentations like engaging lectures, insightful sermons, and impactful public speeches of any and every kind delivered to diverse audiences. Then dramatic or dramatic musical works. Then choreographic and pantomime works, we could say. Then musical works and compositions, both with lyrics and without. Then cinematographic works or those considered equivalent. So even the creation of videos, a video like this one or an educational video production falls within this category. Works of art, of drawing, of painting, architecture and sculpture. Lithography, all forms of visual art, photography and forms similar to photography. So think of classic photography, the kind on an optical medium, on film, a movie reel, as well as current ones where the digital camera captures an image directly as a digital file, storing it for immediate access and viewing. Works of applied art, that is, applied to art, is a general term that also includes works of design, for example, illustrations, maps, work plans, sketches, three-dimensional works, topographies, architectural works, okay? All these types of creations fall under copyright protection. You can see there's also a second part here. In this case, I'm not referring to the Berne Convention, but to another international treaty, which is recognized by more or less all the industrialized countries in the world, the TRIPS, Agreement on Trade-Related Aspects of Intellectual Property Rights. It states that under copyright protection, computer programs are also included, so software, okay? And compilations of data or other materials, so databases, data sets, okay? So I know that for the people who follow this kind of content from me, probably software and databases are the most important, the most central creations, okay? There's also another form of creation that still falls under copyright protection is derivative works. The Berne Convention, still in Article 2 but in paragraph 3, says that translations, adaptations, rearrangements of musical, literary or artistic works of any kind, if they are sufficiently creative, are all protected by copyright. So, for example, consider this scenario. A talented film director who meticulously creates a detailed screenplay based on an original novel that was skillfully written by another accomplished author. They effectively create a new work that is clearly a derivative work of the original novel. But since the director has personally written the screenplay and thoughtfully added their own unique and significant creative input, they rightfully hold the exclusive copyright to this newly developed screenplay. Okay, that makes sense. Sorry, the same example applies to software as well. For instance, taking source code originally created to operate a printer, developing it, reworking it, and turning it into something that operates a device for measuring seismic activity. That is a derivative work, software derived from the original. So, the person who adapted, developed, and modified the software to make it into something else holds an independent copyright on the derivative part, on the new creation, on the derivative work, okay? Let's proceed. Collections are also protected. So the act of gathering, the activity of collecting independent works is in itself, let's say, enough to grant copyright to the person who created this collection. A classic example is, well, they're not used much anymore, but in the 80s and 90s, music compilations. You would see CDs or audio cassettes where a series of songs were collected, and the person who curated this collection had a copyright on the collection itself, which is a separate copyright from the individual songs included in the collection. Another slightly more academic and scientific example would be collections of conference proceedings or articles presented at a conference or scientific event. So, the editor of this publication is the one who coordinates the collection of these materials, organizes them in a certain way, and provides guidelines to ensure they are as coherent and consistent as possible. The various authors of the articles retain the copyright to their individual articles, while the editor of the collection holds the copyright to the collection itself. Okay? However, there is a particular form of creation that we need to be aware of, which is that of databases, and it's a form of protection that we have only in Europe. In other words, the European Union has decided to protect databases in a different way compared to what happens in other countries around the world, mainly in the United States. In the United States, this form of protection does not exist. They have chosen to proceed differently. And so you see, we call it, so it's no coincidence that it's called a sui generis, right? Precisely because in Latin, sui generis means that it is different from all other rights, okay? It could not be assimilated to any type of right previously conceived by legal science. And so it's important to know, first of all, to give a definition of what a database is in the legal world. In European Union law, a database is defined as a collection of independent works, data, or other materials, arranged in a systematic or methodical way and individually accessible by electronic or other means. This is the definition provided by the 1996 European Directive on, let's say, the definition of a database according to European law. It therefore introduced a dual system of protection. Why dual? Dual because there is still copyright which covers, see, this is the first layer of protection, which covers the activities of copying and reproducing a database. But then there is the sui generis right, which I already mentioned, that covers the activities of extracting and reusing substantial parts of the contents of the database. Okay, these are two different things. One thing is making a copy of a database. Another thing is extracting substantial parts from the contents of this database. Okay? I'll close the loop by clarifying what is not protected by copyright, because we also have this, let's say, we also need to look at the negative side. We could say, look at the issue from the negative perspective. What is not protected by copyright? Here, we are still using TRIPS as our source. In Article 9.2, they tell us this: what is not covered by copyright protection. Ideas, that is, abstract ideas, are not protected by copyright because for an idea to be protected by copyright, it must be expressed in a creative form, in one of those forms we have seen. Book, literary text, musical work, cinematographic work, photographic work, software, database, so it must take at least one form. An abstract idea alone is not enough. Procedures are not protected by copyright, nor are methods of operation, and especially not mathematical concepts. A mathematical concept in itself cannot be protected by copyright because it is not creative, it is mathematical. Okay? I think this is pretty intuitive. So what is protected? As it says here, copyright protection extends to expressions, that is, to how I express an idea. It is this that makes the idea eligible for protection. It's the way I describe the mathematical concept that grants me copyright. So I can write a math textbook, an algebra textbook, and have copyright over the textbook, but not over the mathematical concepts written in the textbook. Is that clear? And so we come to this diagram that I often use in my lessons and courses because I think it's quite effective and it helps us understand everything in a single slide. Thank you. in a single image how copyright works. On one side, we have the general rule, you see? Everything is under copyright, right? The general rule states that all creative works are protected by copyright through a sort of automatic process. In other words, they are automatically protected by copyright because you don't have to do anything to protect the work. That is, copyright is not like a patent or a trademark, which require a registration process, but the author becomes the holder of the right with the simple act of creation. So, the moment I have written the article, taken the photograph, or finished developing my software, I already hold a copyright. And this copyright essentially lasts for my entire life, let's say the life of the author, and for another 70 years after my death. After this period, the work enters the public domain, as they say, okay? That is, the copyright ends and there are no more restrictions, so the work is free, available for everyone to use without needing to ask the author's permission. This situation is a bit, as you can see, all black or all white, so there aren't, explained this way, any shades of gray between these two extremes. So you see that we need to look at the other side of the picture and realize that there are exceptions to this rule, exceptions that establish free use. That is, even when we haven't yet reached a situation of public domain. So when the work is still under copyright, there are situations provided by law or by other sources that allow us, as users of works, to have a certain degree of freedom in how we use them, okay? Without having to ask the author's permission every time. These exceptions can be, as you see, either established by law, okay? In American law, they call it fair use. This principle is the principle of fair use, meaning a principle according to which if the use is proper, if it is fair, it is not harmful to the commercial exploitation of the work, then under certain conditions it is allowed, it is permitted, and the rights holder, the author, cannot complain. In the European legal system we do not have fair use, but we have something different, which are specific exceptions established by law. So in the various laws of the different European countries, there is a long list of articles that establish how and when we can freely use works without having to ask the author's permission. However, there is another source, let's say, of this free use, which is open licenses. I use the symbol CC, which stands for Creative Commons, because these are the most famous open licenses, the ones that have become, for over 20 years now, a sort of reference standard. And so in this case, free use is not established by a formal law, but rather by a specific contractual act, which is precisely the explicit license that the author themselves thoughtfully applies to their creative work. So the author or the publisher, the producer, in other words, the rights holder of the work, tells us that they authorize certain uses in advance, certain free uses, through the application of a license. I put my license on these slides as I have already explained. These slides of mine are under a Creative Commons license, which you can find at the end of each chapter of my slides, and it means that I am authorizing you to make certain free uses of them. So the exception to the general rule can be found directly at that link that I, as the rights holder, place at the end of my slides. Is this mechanism clear? So in this diagram you have everything you need to know. To understand how copyright works, it's clear that I'm simplifying a lot here. When I do training courses or university lectures, I sometimes spend 40 minutes or even an hour just on this slide, and we go through a whole series of examples. For now, just accept it as it is and use it as a reference. I can also provide you with a series of texts and reference links to explore further, for example, the concept of fair use, the concept of public domain, and the concept of Creative Commons, as well as how Creative Commons licenses work. Thank you. This was the first part. I hope you understood, that you now have a clearer idea of how copyright works, and that you've cleared your mind of a number of urban legends that I'm sure you too have heard in the past.